Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, which is sponsored by our Tort Litigation Practice Group, which includes particular focus on the retail, food service, and hospitality industries. In light of Governor Whitmer's Executive Order 2020-110, Michigan's getting back to work. We're certainly happy about that, so our focus today is reopening safely and in accordance with state public health guidance. We're also going to take a deep dive into the potential legal issues that businesses face during the COVID-19 pandemic. Fortunately, we have with us today three of Plunkett Cooney's Tort and Litigation Practice Group members, Matthew Cross, Kate Neiswander, and Rick Simchek, all of whom have been studying the complexities of reopening the economy and the potential legal liabilities you could face in the future. Before we get started, I'd like to take just a few moments to provide you with some background about today's speakers and about our law firm. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Now, just a bit of information about today's presenters. For nearly a decade, Matthew Cross has handled an array of claims on behalf of clients directly and through insurance coverage. His experience includes premises liability, municipal liability, employment claims, and personal injury disputes. Matthew is a member of the Michigan Association of Municipal Attorneys, and he serves as regional chair of the Michigan Defense Trial Council. Like Matt, Kate Neiswander has been practicing law for nearly a decade. She serves as defense panel counsel to some of the nation's leading insurance providers, representing their policyholders in litigation. He has a particular expertise in the areas of premises liability, auto and no-fault liability, dram shop disputes, and food-related claims. She's a member of the Oakland County Bar Association and the State Bar of Michigan. Rick Simchek has been practicing for about 42 years now. He manages a diverse litigation practice that includes premises liability, insurance coverage, motor vehicle liability, title insurance, and even some banking law. Rick works with clients including self-insureds, policyholders, and insurance carriers to resolve complex and high-exposure matters. He is a member of the Michigan and Genesee County Bar Associations and DRI, formerly the Defense Research Institute. Now, just a couple of housekeeping notes for today's program. For the Q&A portion of our webinar, we will use the questions widget on your GoToWebinar navigation display. Please take a moment now to locate the widget and feel free to enter questions as they occur to you during the program. At the end of the session, we'll try to answer as many questions as possible. Finally, I want to mention that today's session is being recorded, and that recording will be available on our event page at plunkettcooney.com. Feel free to share a link or direct colleagues to that page. Thanks again for attending today's webinar. Now let's get started. Rick, I believe you're leading off today, so please take it away.
Thank you, John. Thanks to everybody who's on the line with us today. We appreciate you joining us as Plunkett Cooney makes its effort to help you navigate the uncharted waters of the pandemic and the potential liabilities that comes with it. We want to address the risks that come with the very real risks of the potential second wave infection, the consequences of reopening for business, again, here in the United States. What we hope to do is add to your understanding of what to do to manage your business situation and manage your risk. And with that, I turn it over to Matt Cross.
All right, thank you, Rick, and thank you everyone for being here today. I'm going to start things off by talking about the types of lawsuits we're already seeing being filed across the country and other types of claims we anticipate might be filed down the road. And in doing that, we're going to look at these claims from the perspective of 2 different classes of plaintiffs. That would be customers and employees. And our general concern that's kind of overarching throughout this presentation is that courts are going to determine that businesses have a heightened duty of care to take reasonable measures to warn or protect against the known risks associated with COVID-19. So the first potential claim we're going to look at is the failure to train on proper COVID-19 procedures and protocols. As we'll discuss a bit later, businesses have received some fairly detailed guidance from the Centers for Disease Control in the state of Michigan on how to reopen and operate safely. In fact, one of the governor's executive orders, it's Executive Order 2020-91, requires employers to, quote, provide COVID-19 training to employees that covers at a minimum workplace infection control practices, the proper use of personal protective equipment, steps the employee must take to notify the business of any symptoms of COVID-19 or a suspected or confirmed diagnosis of COVID-19, and how to report unsafe working conditions. Now, we'll talk a little bit later about some other defenses to this type of claim and some of the other claims we'll discuss, but proof that you trained employees consistent with CDC guidelines and the executive orders should fairly effectively insulate your business from this type of claim. To that end, you may want to consider having employees acknowledge in writing their receipt of COVID-19 training. And this is the type of claim that can be raised by employees and customers alike. We're still on that. Yeah, there we go. The next claim, breach of duty to warn. As noted in the executive order I just referenced, employees must be trained on how to notify the business of any symptoms of COVID-19 or a suspected or confirmed diagnosis of COVID-19. In turn, businesses then have the duty to warn their customers or their employees of potential dangers like potential exposure to COVID-19. So if you learn that an employee or a customer who may have exposed others to COVID-19, you want to notify your customers and employees at once, perhaps via social media. You do want to, in that notification, specifically mention the dates and times the person was in your business, but you do not want to mention the infected or potentially infected person by name if you happen to have their name. The next potential claim we're going to discuss is the failure to take reasonable measures to protect from the spread of the virus. In addition to providing employees with COVID-19 training, it's important to make sure you're following the recommendations provided by the CDC in the state of Michigan. This includes, among other things, ensuring that staff is wearing face masks, that customers are following social distancing guidelines, and that there's a sanitization protocol in place. Failure to take these reasonable measures could open you up to a claim you failed to take adequate measures to protect employees and customers. We know of at least one wrongful death claim based on this theory of liability that's pending in Illinois against a big box retailer. That claim is based at least in part on the store's supposed failure to cleanse and sterilize the store, to provide personal protection equipment, and to promote and enforce the CDC guidelines. So this is going to be a big one to be on the lookout for. The next potential claim is negligence per se. And in this context, we're talking specifically about the failure to comply with executive orders and the CDC guidelines. Now, in the typical negligence claim, it's going to be the jury that determines the applicable standard of care. And they'll be guided by the civil jury instructions that define negligence as the failure to do something a reasonably careful person would do under the circumstances. Now, compare that to a negligence per se claim where the standard of care is actually determined by law. We see this come up quite often in other contexts. Probably the example that's top of mind would be an auto accident case. We see claims frequently citing the Motor Vehicle Code as serving as the basis for a negligence per se claim. For example, the failure to stop in an assured clear distance. So it's not entirely resolved whether an executive order or the CDC's guidelines can actually provide the basis for a negligence per se claim. However, the second restatement of torts, which we quite frequently refer to when there's an open question, based on what the guidance provided by the second restatement of torts, we think the answer is probably yes, because what the restatement says is really any enactment can serve as the standard of care for a negligence per se claim when the enactment is to protect a class of persons, which includes the one whose interest is invaded, when that order is to protect the particular interest which is invaded, to protect that interest against the kind of harm which resulted, and to protect that interest against the particular hazard from which the harm results. Very wordy way of saying the executive orders are probably going to suffice to serve as the basis for a negligence per se claim. So ensuring compliance with the executive orders and the CDC guidelines is going to be vital. The next claim we're going to talk about is a whistleblower claim, and whistleblower claims by their very nature can only be raised by employees, but For those of you who have not had any exposure to the Whistleblower Protection Act, in essence, it protects an employee or someone acting on behalf of the employee who is reporting or about to report a violation or suspected violation of law. A few things to point out. It must be an existing violation that has occurred or is ongoing. It cannot be a report of a suspected violation of a suspected law or someone's stated intention to violate the law at some point in the future. And according to the Department of Labor website, there have been over 1,500 whistleblower claims filed since February related to COVID. So very real possibility this may be something that comes up for you in the future. Now, it's not really possible for us to provide detailed guidance for every factual scenario that might serve as the basis for a whistleblower claim. But if an employee complains to you that he or she feels unsafe or believes you have not taken proper precautions, it's important to contact counsel. And we'll have our contact information up again at the end of this presentation. And we're, of course, always happy to help you and guide you moving forward. So the next claim, discrimination claims. This is an interesting one. As you've probably heard or maybe even experienced firsthand, there are quite a few people who take exception to having to wear a mask in public. Now, some people oppose that requirement on political or philosophical grounds, but we're going to focus on those who claim to be unable to wear a mask for health reasons. Perhaps not surprisingly, there are some questionable guides making the rounds on the internet, advising those who do not want to wear a mask in public to simply say they have a health condition that prevents them from doing so, and that they have no obligation to disclose that condition, citing the Americans with Disabilities Act and HIPAA. Now, although the ADA does generally require businesses to attempt to accommodate those with disability, that general requirement does not apply when there is a direct threat or a significant risk to the health or safety of others that cannot be eliminated by a modification of policies. Also, I mean, members of the medical community have come out and spoken against these anti-maskers and said, I mean, even for those people who have medical conditions that arguably make wearing a mask difficult, for example, people with asthma, COPD, there's still ways for them to safely wear a mask. And, you know, given that they are uniquely vulnerable to COVID-19, doctors have explicitly recommended that they should use face masks. So the next claim is the failure to protect against third-party assaults and violent acts of others. This is something that's come up even pre-COVID with customers tainting products, licking ice cream, putting it back on the shelf, things like that. We foresee these claims coming up, not just in that scenario, but also when dealing with the unruly customer who refuses to wear a mask and then becomes violent when denied service. So Kate's going to talk a little bit more in detail about this later, but we do have some fairly clear guidance from our courts as to what your obligation is in that scenario. In essence, you'll be expected to expedite the involvement of law enforcement when there's an imminent risk of harm present. Okay, so the last two claims that I'm going to talk about are premises liability and general negligence claims. First we'll talk about is negligent exposure. This is somewhat related to the failure to train and the negligence per se claims we've already discussed. Potential plaintiffs may claim that a business failed to ensure customers maintain a proper distance from each other, that employees failed to wear face masks, or that there was not an adequate sanitization protocol in place. And then the last potential claim, and this is one that's certainly not top of mind. Obviously, COVID-19 is the primary concern, but with the increased cleaning regimen that we're going to be putting in place, and there is a greater risk for creating slip and fall hazards. So although it's not top of mind, that is something that you should keep on your radar. And with that, I'm going to turn it over to Kate, who's going to talk about some guidance for how we can combat these potential lawsuits.
Thanks, Matt. As Matt mentioned, there are a number of potential lawsuits that could arise from the outbreak of COVID-19. However, there are a number of things that businesses can do to prevent potential claims lawsuits. One of the most important things that a restaurant, bar, or retail establishment can do to combat these potential lawsuits is to comply with the current executive and CDC guidelines. For Michigan businesses, compliance with the governor's executive orders 2020-96 and 2020-97 is key with respect to these preventative measures. This is because, as Matt pointed out, the executive orders may be used to impose a heightened duty on restaurants, bars, retail establishments, and other businesses. Now, I'm not going to go through all of the content of these executive orders line by line this afternoon. Rather, I'm just going to highlight several of the requirements set forth in these orders, as well as touch on additional pointers that businesses should be aware of and implement before reopening their doors to the public. Now, Executive Order 2020-97 outlines what specific things stores, restaurants, bars, and other businesses must do before or within a short period of time of reopening their doors to the public. Paragraph 6 of that order specifically addresses the requirements for retail stores. Paragraph 8 addresses bars and restaurants open for dine-in service. And paragraph 1 addresses requirements for all businesses. Now, at a minimum, according to paragraph 1 of this executive order, all businesses within 2 weeks of opening for in-person activities must implement a COVID-19 preparedness plan that is consistent with OSHA's guidance on preparing workspaces. Now, it's important that businesses are familiar with these actual OSHA guidelines, and these are easily accessible online to go through them if you're not aware of these guidelines set by OSHA. But it is important that you're aware that you have to come up with a plan that is in compliance with OSHA's guidelines within 2 weeks of reopening the doors. Now, this plan must be visible to employees, unions, and customers, whether it's via website or a hard copy if someone requests it. Now, all businesses must also designate a site-specific supervisor to monitor and oversee the prevention plan. Now, this means that someone that is in management must be on duty at all times when customers and employees are present. All businesses must conduct a daily entry self-screening protocols. So this means that you can have employees fill out a questionnaire or verbally report whether they have had any symptoms that could potentially relate to COVID-19 or have had potential exposure to someone that has tested positive for COVID-19. If a customer obviously reports yes to either of those questions, then that employee should be instructed to go home and wait until they no longer have a temperature or no longer are exhibiting any symptoms. Now, another requirement of paragraph 1 of the executive order requires that non-medical grade face coverings are supplied to employees. Masks are also required to be worn by hostesses, waitresses, cooks, chefs, and bartenders while inside the restaurant and bars. Now, regardless of whether you've already opened your doors to the public or whether you're waiting to do so, I strongly encourage everyone to read through the Executive Order 2020-97. A summary of the Executive Orders 2020-96 and 2020-97 are published on Plunkett Cooney's website. This summary thoroughly goes through each of the requirements for the appropriate realm of business, whether you're a restaurant, a bar, or a retail establishment, and it can easily be used as a checklist as to what businesses should be doing in this current climate. Now, not only should you be complying with the current executive orders, but it's also important for businesses to look to guidelines and directives published by other organizations. This is such as the Michigan Retailers Association, Michigan Restaurant and Lodging Association, or even insurance carriers. A lot of insurance carriers right now are publishing guidelines as to what they are hoping that their insureds are doing. These are great resources to look to for further guidance, and oftentimes these organizations even provide you with materials that will be helpful for you to post outside your business or to even utilize on your website. Now, as Matt mentioned earlier, one of the potential claims that we may see in the foreseeable future is related to the failure to train and supervise employees. The best way to combat that type of lawsuit is obviously training employees. It is important for businesses to train all employees of the protocols and procedures implemented to reduce the spread of COVID-19. It's not enough just to put certain protocols and procedures in place. Rather, the Executive Order 2020-97 requires that all businesses provide and document COVID-19 training for all employees, and this training at a minimum must cover infection control, proper use of PPE or personal protection equipment, steps employees must take to notify the business if and when exhibiting symptoms, appropriate cleaning procedures, and how to manage symptomatic customers upon entry into the store or restaurant or bar. The executive order also requires that businesses train restaurant and bar employees on food safety health protocols. This requires cleaning between customers, especially shared items like condiments and menus. Now, another way to combat potential lawsuits is by warning the public of potential dangers and business protocols regarding COVID-19 near public entrances. Now, paragraph 6 and paragraph 8 of the Executive Order 2020-97 requires that retail stores, restaurants, and bars provide communication materials, whether it's via social media, business websites, signage posted outside the building entrances, or pamphlets that informs the public of changes to the business's practice and the precautions that the business has taken to prevent the spread of COVID-19. Now, these signs need to be placed in, if you're utilizing signs, they should be placed in a location that is easily viewable by customers before entering your business. And there should also be signs posted that require customers to wear face coverings outside of the business. Now, for restaurants, customers are required to wear masks until they're seated at their tables. And for stores, customers are required to wear masks at all times. There should also be signs or posters posted that discourage ill-feeling customers or patrons from entering your business establishment. And because there are limitations as to the capacity of specific types of businesses, whether it's a restaurant or bar or store, there should also be notices posted near the entrance indicating that there is a limited capacity. In scenarios of restaurants and bars, it should also be posted that reservations are required or most likely necessary in order to ensure service. We can actually move on to the next slide because we're going to address additional ways that we can combat potential lawsuits. Now, one of the methods that is something that's suggested, not necessarily required by the executive order, is considering making businesses, specifically restaurants and bars, open as a reservation-only method. So to avoid potentially surprised or hostile customers and patrons when they are told that they're unable to get a table at X amount of time, it may be helpful to implement a reservations-only policy. You can utilize applications like Resi or OpenTable. I don't know the fees associated with those, or you could even incorporate a reservation-only policy on your website and social media page and have an option on those websites so that you can ensure to try to appease as many people and give everybody a heads up. Also with the reservations and even a confirmation email, you could indicate that there are specific requirements for customers who are inside the restaurant, such as wearing a mask unless seated at the table. Now, it may also be wise to place limits on the group size of parties to ensure that there's adequate distance between the tables inside your restaurant. I know in the past you'd have probably a lot of requests for 10 to 12 individuals in a party, but now given the current climate and the restrictions as to distance between patrons, it's important that there's somewhat of a limitation on the group size of parties. It also may be wise to limit the length of reservations, and this is primarily to ensure that businesses can still make a profit at 50% capacity. So unless individuals are continuing to order drinks and dessert, there's not much of a profit that can be made if a customer is just continuing to sit at a table to socialize. Another helpful recommendation, and it's not even just a recommendation, but this is also a requirement set forth in the executive orders, is to implement protocols and procedures that encourage customers to remain 6 feet apart. Businesses should design spaces in a manner that encourages employees and customers to maintain social distancing. There should be tape at, whether it's X's or just markers on the floor, 6 feet away from each other so that customers know how far to stand apart when in line. Tables and seating in common areas should also be separated by at least 6 feet. And waiting areas in restaurants should be closed, and customers should be asked to wait in their vehicles and wait for a phone call indicating that their table is ready. Because it's difficult to ensure adequate social distancing at bar counters, at-bar service should also be closed, or if you choose not to close at-bar service, there should be shields placed in front of the bar to obviously protect the bartenders and barbacks, but there should also be something that prevents chairs from being moved too close together. I know it's also problematic when we're dealing with at-bar service because you don't know the size of the party that's going to come in. So just for purposes of controlling both capacity as well as ensuring social distancing, it may be best just to close the at-service bar area. Now, due to the fact that customers frequently congregate in restrooms, it's also important that businesses try to limit the number of customers in public restrooms at a time. This may be done by having a restroom attendant or designating a specific employee who frequently monitors restrooms. Now, one of the most important things that businesses can do is adequately clean and disinfect their premises in order to further combat potential spread of COVID-19 and to further combat potential lawsuits given the current situation. Now, it's important that businesses establish an enhanced cleaning and sanitizing protocol for frequently touched areas like tables, booths, chairs, menus, shopping carts, keypads, credit card machines, and counters. A team member should be designated to frequently wipe down those high-touch areas, and a floor team member should also be designated to conduct restroom checks, to wipe down toilet handles, push points on doors, sink handles, hand dryers, paper towel dispensers, and other frequently touched surfaces. Now, there's something else that Matt addressed earlier, is the importance of calling 911 or the police when there is an imminent threat present. Now, it's important that businesses train their employees, especially those designated as hostesses or greeters, as to when it's necessary to call 911 or the police. Michigan law requires that restaurants, bars, and stores to reasonably contact the police when the circumstances give reason to believe that a specific person poses an imminent threat of harm to others. This means that police should be called when certain words or behaviors cause an employee to believe that a specific person, likely a hostile customer, poses an imminent threat of harm to others. This can exist when a customer licks products and surfaces, given the current circumstances, when a customer becomes heated and having to wear a mask and threatens to harm an employee, customer, or just the general public, when a customer becomes irate and out of control for whatever reason, when a customer or person has a weapon and gestures or threatens to use it. So if any of those scenarios apply, all employees should be trained to call 911 right away, not to wait to call management. Now, there are scenarios where it's kind of a judgment call whether you should involve management or call 911. These are scenarios that is specifically when a customer refuses to wear a mask because of claimed health reasons. Now, if that customer is not becoming hostile, it's not necessarily a threat to the public, like the extent of someone intentionally licking products or surfaces. In that type of scenario, I would recommend is that either the gatekeeper, the hostess, or the greeter contact management to ascertain more so why the reason why the customer does not wish to wear a mask. It would not be unreasonable for the store to indicate to the individual who refuses to wear the mask that they're not permitted to enter the store. However, that is definitely a judgment call in how the store would like to handle that type of situation. Now, there are scenarios where police do not need to be called. This is usually scenarios where a customer does not maintain the distance. So if the customer is just not keeping up with or paying attention to how close he or she is to others, and this is because the determination is fluid and too difficult to enforce. And now I'm going to pass the mic back to Matt, who is going to address a few more steps businesses can take to thwart potential lawsuits.
I'm going to pick it up at the point where hopefully this scenario is not one you have to actually deal with yourself, but the big question, and that is what to do if an employee or a customer tests positive. And the real question that I'm sure you're asking is, well, should the business temporarily shut down to deep clean and decontaminate the store? The answer, unfortunately, is not all that straightforward. It's really a judgment call. You need to weigh the pros and cons of shutting down altogether. You do want to put the public on notice as soon as possible. We mentioned before about using social media to make people aware of a positive or suspected positive diagnosis of COVID-19, providing the details, the given date that the person was in the business, the approximate time they were in the store before their diagnosis. But again, very important not to mention anyone by name if you happen to have their name. So the next thing we're going to talk about is ensuring premises are free of potentially hazardous conditions. This goes with our general negligence and premises liability cases we talked about, which again, I realize are not necessarily top of mind, but it's still something that we have to keep a lookout for. And how to protect customers from increased risks of slip and falls. You're probably already doing some of these things. Placing floor mats under public hand sanitizer dispensers to prevent slip and fall hazards. Posting protocols for proper use of Clorox or disinfectant sprays. Increasing inspections of areas where you have these potential hazards. And that segues nicely into the next slide, which is arguably the most important information you could walk away with today, and that is documenting incidents. And we're talking not only about where you have an eyewitness to something like a third-party assault that we talked about before, and getting witness statements from employees and customers. But we'll talk about some other scenarios where documentation is important. But for actual witnesses, you want to make sure you get enough detail, full names, contact information, so you can follow up down the road if necessary. And you'll also want to make sure you preserve video, any surveillance video, if applicable, should litigation arise in the future. The next piece of advice, which we've already talked about before very briefly, and that is documenting training provided to employees. Again, that executive order requires COVID-19 training, so it's going to be important that you have documentation to evidence that you've given that training. You'll also want to document inspections and cleaning routines. Again, I know some of you probably have set, every 3-4 hours or once a shift, people are supposed to walk the floor and see if there are any hazards. But you'll want to document that because, again, with most of these potential claims we discussed, the ultimate question will be whether you acted reasonably. And if there's nothing documented, it may appear that you've done nothing, which would obviously be unreasonable. So you may be able to prove otherwise using other methods like employee testimony, but really it's contemporaneous documentation that is ideal and will likely carry greater weight with the jury should you get that far. So, all right. So I'm going to wrap up my portion by talking about how you can leverage your social media and protect your brand image online during these unprecedented times. So a good first step, and I'm sure many of you have already done this, but promoting your pandemic operation changes and policies. Really just letting your customers know that you're taking this seriously. You have precautions in place that it's as safe as it can be for them to come out and patronize your business. So you may want to consider designating and empowering a social media coordinator if you haven't already done that. Promote specials, discounts, photos of happy mass customers. I can speak from personal experience when I say that those social media posts went a long way to making me feel comfortable leaving the house to check out some of the local businesses. So promote online ordering if it's available. Same with curbside delivery if you prefer that. Promoting online reservations, which Kate talked about a bit earlier. And then protecting your brand, your image online. You'll want to very quickly follow up with poor ratings or feedback. The anti-maskers we talked about before who were, dropping messages on your Facebook about how ridiculous it is you're making them wear a mask. You want to follow up quickly on those, and if to the extent possible, respond and try to make things right. It may involve direct messaging those customers to try to fix the issues. And if you are able to fix their issue, you certainly encourage them to reflect that on their comments, whether it's on the same thread or just something to let your customers know that you are taking this seriously, you're trying your best to keep everyone happy. And then lastly, really attempting to cram down negative comments with positive posts and ratings. So with that, I'm going to turn it over to Rick to talk about some potential defenses to lawsuits once they are initiated.
Thank you, Matt. We're going to talk about what happens when the worst thing happens. When the lawsuit gets filed, how do we respond based upon what we know about the pandemic and what we know about what was done in response to the pandemic? We are much like the generals who always fight the last war. We're lawyers and people in this field. We are prisoners of precedent. So we have a tendency to look backwards to try and understand what's happening now and in the future. To that end, we look to traditional defenses to even something as unpredictable and as unprecedented as COVID-19. One of those defenses might be act of God. In this case, an unavoidable force of nature that so overwhelms human response that it's not possible to control it. Usually we see this defense offered in circumstances where there's a flood or a tornado or some sort of natural disaster that's inevitable and unavoidable. But in this instance, an argument could very well be made that the pandemic, the spread of the transmission of the virus was at one point totally uncontrollable, may still be considered uncontrollable, And of course, with the potential of the second wave of infection, continues to be uncontrollable, so that even in a circumstance without human agency, there is a defense that this was simply a force of nature. The issue of human agency transforms the defense and makes it unavailable because it's no longer just a force of nature or just the act of God. Instead, we then have the issue of force majeure, which, as a defense, deals with, again, an unexpected and uncontrollable event, but this one much more like the issues of, say, a 9/11 terrorist attack, or in a circumstance like that, or the failure of a particular system. This is a different type of defense. Again, we have the potential for human agency involved, but in this instance, it was unanticipatable. Let's take the issue of a hospital. Hospitals could not have anticipated, could not have responded to the demand made for their services. So even in the sense of a healthcare provider delivering services and being held to account because they weren't able to deliver care in a way that met the standard of care, we have an issue of an uncontrollable event and an unanswerable event in the pandemic that provides a defense. Moving on to the other additional potential defenses that we see, there's the issue of meeting the standard of care. This is next, as we see in the next slide, we talk about what standards. Well, obviously that's a moving target in a circumstance as dynamic as the pandemic. But as we discussed earlier, resorting to the directives, the executive orders, the emergency response plans, to be able to point to a documented response that shows compliance may very well provide a defense, and a complete defense, to a claim based upon exposure and infection to COVID. So if you can say, well, look, we got the OSHA plan, we followed it, here is our questionnaire that our employees filled out every day, here was our disinfection and sanitization plan, that would go a long, long way to defending a COVID claim against a open to the public type business. And with regard to even a claim by employees, a defense even to the idea that, well, you certainly knew that this was going to be a serious event and you intentionally exposed us in the meatpacking plant to the virus. But if the meatpacking plant can then say, well, look, we followed everything that OSHA required, everything the federal government required, everything state government required, then there is a potential for a truly built-in defense. Now, the other side of that is a defense we see as an excused violation of a statute under Michigan Civil Jury Instruction 12.02, which says a party using ordinary care was still unavailable to avoid the violation because, and then the reason becomes important, then the violation is excused. In other words, what could be done was done, and even in the face of that, the infection or the spread or the transmission occurred. Now again, there are issues that are beyond the control of any human actor, and there are reasons that can be introduced in circumstances. Let's say a shortage of supplies. We couldn't get enough masks to cover our employees. We couldn't get enough hand sanitizer on the floor. We did the best we could with everything we had, and still we had an event, still we had an issue of liability. But asserting the statute, we can say, we did everything we could, there was no more that could have been done, we have a defense under the statute. So either way, either compliance or the inability to comply for justifiable reason may very well provide a defense to someone exposed in this way. Moving along to the next slide, we've got the issue of identifying and working with proximate cause. What we're dealing with here is how does one actually prove that there was in fact an exposure? If there was an exposure, someone was infected, they tested positive, they had the symptoms, where did that exposure come from? Did that person wear a mask? Did that person go out more often during the stay-at-home order than was reasonable, more than for essential items? Was there are these the people who will eventually file their suits after having participated in the pool party in the Lake of the Ozarks? How will we tell which person in the pool was the one who was the carrier? This not only talks about proximate cause, but it also addresses how will we prove that. And moving along to the next slide, talk about comparative fault. In this instance, what measures were taken by that person, the wearing of the mask, participation in events, maintaining social distancing, all of those which, quite frankly, no one can claim they don't know about. All of that will factor into the matter of comparative fault and whether some person contributed to their own exposure and inspection. What may be the answer to all of this, and whether we can say it's the perfect answer is perhaps arguable, but in this instance, can government legislate an immunity with regard to this pandemic? Can we say that in the absence of gross negligence or some other higher standard of liability, higher standard of proof, that we were not going to hold buildings, businesses, organizations, schools to account for an exposure because this was an unanticipated and perhaps totally unpredictable event? We're already seeing varieties of legislated immunity arise in states like Kansas and Oklahoma. In Kansas, a gross negligence standard for medical professionals, unless someone can prove that the medical professional was grossly negligent in treating the virus, there's no liability. That certainly could be expanded to other potential defendants, business owners, building owners, schools, defendants like that. In Oklahoma, they're already legislating that proof of compliance with directives, orders, government emergency response plans will provide a certain amount of immunity to claims by both employees and customers, as well as invitees, versus defendants who operate as a building or a business. Obviously, there's the potential for fairness and due process arguments against such legislated immunity, but under the circumstances, I think we can anticipate seeing a response by government depending upon what happens between now and the second wave of infection and whether we go back to another stay-at-home order, another closing of businesses, a repeat of what we saw at the end of March till virtually now. With that, I hope we have some questions.
Thanks, Rick. The time has come for Q&A, and I just would like to encourage everyone to take a minute and use the questions feature on your GoToWebinar dashboard. Type in any questions you may have right now. I do know there was one submitted regarding some concerted employment activity. I think probably what would be best in this instance is if we refer you to one of our employment attorneys on that. So I'll take that question offline. So again, if you would like to, type in your questions now in the questions queue. I do have one question here that I can give the group, and it is, do employees ever have the duty to physically intervene when dealing with an unruly or violent customer?
I can take this one, John.
Okay.
Or if Rick,
Please
if
do.
you want to go.
Yep.
Oh, go ahead.
Yep.
Go ahead.
The only duty that a restaurant, bar, or retail establishment has with respect to unruly or hostile customers is merely to reasonably involve the police. So calling 911 or calling your local police station is the only duty and the only thing that a business has to do to protect other individuals from potential harm. With respect to the duty to intervene or do something to prevent future harm by this hostile customer does not extend to anything besides just reasonably involving the police. And the reason being is that our Michigan courts have explained that criminal activity is not something that you can easily predict, and it's assumed that, well, everyone, including customers, will obey the law and will not become violent in threats to others.
Great, thank you for that. Again, please take a minute now and type in your questions. We have another. What form would a blanket COVID-19 immunity by the state look like for businesses?
John, I'll field that one. The idea would have to be patterned after prior immunities, like governmental immunity that we have for certain functions of essential functions of government for which there is no responsibility. In certain circumstances, government, like an auto accident, certain auto accident scenarios, a government actor has to be grossly negligent. In other circumstances, under Good Samaritan laws, a person rendering medical assistance in an emergency situation is not liable for any alleged negligence in performing those emergency medical services. We simply transpose that concept to the idea that we were confronted with an event beyond human control, and to the extent that a person experienced a damage, even with the involvement of human agency, but that is rooted in exposure and infection with COVID-19, then we are not going to hold the human agent involved in that exposure to account. We're not going to hold them liable. Now, again, there can be gradations. We can limit it only to claims where there's gross negligence, and ordinary negligence would not give rise to liability, and it would have to be proof of gross negligence or willful and wanton misconduct or intentional exposure. So there is precedent for this in other circumstances. Applying it would no doubt be different because of this particular circumstance that we're facing because of a pandemic, but it's certainly possible, and we see that states are already on their way to this.
Great, thanks, Rick. Last question. I don't see any others popping in right now. So the last question is, if our restaurant takes advantage of recent efforts to expand seating to outside areas like the sidewalk in front of our establishment, how could that change our liability, if at all?
Well, any expansion obviously would have, first of all, you'd want to make sure that you're maintaining social distancing while that was in place, while those requirements are in place. You also have some other issues, of course, being outside versus inside in normal circumstances. I'm sure someone else can speak to that.
Just to kind of add what Rick was saying about other potential dangers, you have the possibilities of there being potholes outside, any kind of potential tripping hazard, not so much slipping, but there's a lot of tripping hazards, and also making sure that patio furniture, which sometimes is a little bit more rocky, is balanced and repaired. I mean, it's mostly the same things that you would be looking for inside, but there's just a lot more outside that could be a potential tripping hazard. So those are important things to pay attention to. And with respect to ensuring safe businesses, I know that it's a little bit safer to be outside, at least that's what the CDC says with respect to the spread of COVID-19, but it's still important that people are maintaining the distance, and when up and walking around, it's important that they are wearing masks just to protect themselves. And I know also if you have certain type of furniture, it's a little bit harder to clean. I know that there's conflicting views on how long COVID-19 can stay and live on certain surfaces, but if you have, for example, picnic tables that are wood, it's a little bit more difficult to clean those as opposed to something that's a finished table that's inside or something that's plastic. So that's something you also have to take into consideration as just the difficulties of cleaning the actual materials that are outside.
A follow-up to this question just came in as well, and it's the question is basically asking, do they need to inform their insurance provider if they were to take advantage of the additional outdoor space?
I would say definitely yes. You want to make sure that everything's covered if there is a potential claim. So they need to be on notice, and usually they assess, unfortunately, premiums based upon the actual area that is being insured. But definitely inform your insurance agent. Make sure that that insurance agent actually follows up with your insurance carrier just to avoid any potential things down the road.
This is clearly the time when one should take their insurance policy and read it right down to the fine print.
Or call your attorney to do so.
I don't think anybody wants to read those. Well, that's all we have. I don't see any other questions, so I'm going to go ahead and wrap up. We made it through. It was a little rocky, kind of like this whole COVID experience, so thanks everybody for hanging in there. Just want to mention that when you complete your login here, you'll get a pop-up webinar survey. We'd really appreciate it if you take a second to fill that out. That feedback helps us with our additional programming, so we'd love to get your feedback. The other thing is this recording will be available later today, hopefully, on our event page. So if you wanted to review it again or have others in your organization review it or even refer it to a colleague, please do that. It'll be on the event page along with the PowerPoint slide deck. And lastly, we just wanted to give one quick promotion for our group here. The Litigation Defenders blog that this group maintains is out there. If you've not seen it, we invite you to check it out on our website. We have 6 blogs here at Plunkett Cooney, and Litigation Defenders is one of those, covering a lot of different general liability issues. So you can also subscribe by email and you'll be notified when new content is added. So on behalf of Kate, Matt, and Rick, I want to thank you very much for being here today. Stay safe out there. Hopefully everything goes well for your businesses in the next couple of weeks and we really get back to some semblance of normal. And with that, have a great day.